Good morning, everyone. And welcome to this briefing, which, as you know, is part of a series of virtual briefings with the support of Wilderness Foundation Africa and ICCF. And thank you, as always, to the honourable members for making time. We have a couple of apologies from the IFF, the UDM, because they are either with the speaker or with going to King Goodwill's Willatini's events. And I know the chairperson, when he joins us, also needs to leave a little bit earlier, but we are recording this so we can then also, again, give it to honourable members to listen to later. And I always, as always, just want to thank the chairperson of the Portfolio Committee, the Honourable Kasa, for hosting this briefing. Without him, we couldn't do it, of course. Now, as we discussed last week, this week's briefing is on environmental legislation, how it works and what is not working. And we are privileged to have a group of super impressive and clever people to address you on this topic. So I just want to explain the order of the day. We're going to do it slightly differently. Our first speaker will be Dr. Melanie Mercat. She will set the scene with a few opening remarks on Section 24 of the Constitution, the meaning of environment, and a few other issues. She will then be followed by three speakers from the Centre for Environmental Rights, who will touch on key pieces of legislation, some challenges communities face in relation to the environmental governance, and the One Environmental system. They will be Nicole Lozer from the Centre for Environmental Rights, Matomi Kapa, and Liani Govindsamy, I hope I'm saying that correctly, Anne, who are all three from the Centre for Environmental Rights. And then when they are all done, Dr. Mercat will circle back and talk a little bit about the biodiversity and protected areas. And then there will be the usual questions and discussion. So slightly different order than usual, but I think that will actually work. I've also asked them, I will introduce Dr. Mercat just because she's going first, but I'm not going to keep you by reading all of their incredibly impressive CVs. There's a lot of LLBs, LLMs, cum laudes and summa cum laudes there. So I'm not going to do that all up front. So I've asked them to just each, as they start talking after Dr. Mercat, just say a little bit about themselves, what they do at CR, and a tiny bit of their background so that you can contextualize them as they're speaking. Otherwise, you'll just forget. I hope that's okay. So our first speaker is Dr. Melanie Mercat, who is a senior lecturer in Department of Public Law at the University of Pretoria, where she teaches, amongst others, environmental law. She got her LLB from UCT, LLM from the University of Pretoria, both cum laude, I warned you, and an LLD from Northwest University. There's a lot more to the CV, but I think that about sort of puts her in context. So Dr. Mercat, over to you, and then you guys can just seamlessly, the speakers can just seamlessly go from there. Thanks.
Great, thank you so much for that introduction, and good morning, honourable members. Can you all see my screen and hear me?
Yes, we can. It's all perfect. Thank you.
So in any discussion about environmental legislation, it's always useful to remind ourselves of the constitutional mandate for the protection of the environment and to reflect on the Constitution's overarching social justice imperative, bearing in mind that it is the environment that creates the conditions in which social justice occur, in that a well-functioning environment is a prerequisite for human flourishing and indeed the fulfillment of all other constitutional rights. Our environmental right in Section 24 imposes positive obligations on the state to protect the environment in a way that secures both inter- and intra-generational justice through reasonable legislative and other measures. Now, you'll be familiar that reasonable measures are those that, among other things, take into account the needs of the most vulnerable in our society, again, reminding us of that social justice imperative. The measures must prevent pollution and ecological degradation, promote conservation, and secure ecologically sustainable development and use of natural resources. You'll see that I've underlined the term ecologically sustainable development and use because there's a loss of emphasis on that, which is something I'll come back to later. The Constitution also tells us that legislative and other measures can promote economic and social development so long as it's justifiable And that idea of justifiable economic and social development is also something that we should constantly bear in mind. Now, there are many legislative measures aimed, in theory, at giving effect to Section 24. We will focus on just a few today, but it's useful in reflecting on the scheme of environmental legislation in South Africa to think about what the subject matter of environmental law is, the environment. And so in thinking about what the environment is, we can have regard to South Africa's framework environmental legislation, the National Environmental Management Act, NEMA, which defines the environment as the surroundings in which humans exist, made up of, among other things, land, air, and water, short for law, and plant and animal life, as well as cultural and aesthetic properties that influence human health and well-being. Two features of this definition likely stand out to you immediately. First, the human-centered nature of the definition, and second, the breadth of the definition. The implications of these features include recognizing that as human life has impacted on essentially every facet of the environment, every nook and cranny of the Earth's systems, the scope of environmental law is broad. It relates to land use and management and planning, what we like to think of as the natural environment, the distribution of environment, water and air, and also how environmental harms are governed and distributed. Now, the definition, broad as it is, also allows us to confront our many interactions with nature, and some of them are reflected here. In our day-to-day lives and the ways in which these interactions have broader and often devastating impacts on Earth systems. And some of these impacts are reflected in the pictures I've just put up. We can also think of the ways in which access to environmental goods remains very unequal in our country, and how environmental harms continue to be disproportionately felt by South Africa's poor. Facts that are both recognized in the preambles of most of the environmental legislation we'll be looking at today. Now, some of the laws we don't have time to discuss today, but which are increasingly relevant, include, under this heading, land, the Spatial Planning and Land Use Management Act, which regulates land use and seeks to respond to the specter of spatial apartheid. We also have, regulating air, the newly introduced Carbon Tax Act, which seeks to incentivize producers to reduce their carbon emissions through the imposition of taxes, and thus protect the atmosphere and respond to climate change. Regulating water, we have the Marine Living Resources Act, which seeks to ensure equitable access to marine life, but also to conserve marine life, and thus to protect the functioning of ecosystems in our oceans. And there are many other laws that are listed here. Some of them we'll touch on, and I'll be focusing on the laws here that are aimed at protecting plant and animal life. But what I'd like to take away from this slide is to think of the environmental laws in a holistic way, given that humans exist in environments and that the environment, as I've said before, creates the conditions for social justice to occur. Now, one last point before we move forward into the detail of environmental legislation is that it's helpful to think of our environmental laws as interconnected and with reference to a hierarchy of norms, with the Constitution being the highest order norm, imposing its environmental right, but also rights to dignity, to life, to access to water, access to food, access to housing, and thinking of all of these rights as mutually reinforcing and related. And then beneath the Constitution, to think of NEMA, the 1998 framework statute that's meant to be read with and understood alongside all the specific environmental laws. And then finally, with the detail coming from the regulations enacted by or promulgated by the various ministers responsible for them, primarily obviously the Minister of Environmental Affairs, and to think of these laws as all aimed at protecting the environment as all in an interrelated way aimed at ensuring the overarching goals of the Constitution, albeit that they address different media. And so at this point, I'll hand over then to the Center for Environmental Rights to focus on NEMA and SEMA's specific environmental management acts aimed at regulating pollution and mining, among other things. Thank you.
Thank you, Melanie. And good day, honorable members. It's great to be here today to present to you. I see my colleague Nicole is sharing our presentation. Given that Melanie has already presented on the kind of overview of environmental legislation reflecting on the hierarchy of norms, etc., we're going to skip right into our slide 3, which deals with the preamble to NEMA. And it was important.
Will you just introduce yourself before you go too far?
Okay, thanks, Melanie. Sorry, everyone.
Sorry, can I also just ask if you're seeing the slide properly, or Leanne, is it showing okay?
We are seeing it as a double, but I think it's okay, don't worry.
Okay, let me see if I can fix that.
Okay, while Leanne is introducing herself.
Okay, so my name is Leanne, and I head the Corporate Accountability and Transparency Program at the Center for Environmental Rights. Okay, and my colleagues will introduce themselves as they go along into the presentation. So let me get back into the slides and to slide 3, which sets out the preamble to NEMA. And it was quite important for us to reflect at this point, because you often kind of skip over the preamble and the objectives of environmental legislation. And I think the preamble is a very good starting point to have that reflection. So one of the important aspects that are reflected in the preamble, and I'll focus on just one or two, is around sustainable development. And Melanie's already reflected on some of this. So sustainable development, right, requires the integration of social, economic, and environmental factors in the planning, implementation, and evaluation of decisions to ensure that development serves present and future generations. And I think now more than ever, as the country is really focused, and so many government departments and entities really focused on reconstruction and recovery, that this committee bear in mind what its oversight role is in respect of sustainable development and ensuring that considerations around environmental protection and ensuring the health and well-being of people in relation to developmental projects is really a top priority. So that oversight role, I think, is quite critical. And if we move on to slide 4, and we reflect on what the preamble states in terms of the law establishing procedures and institutions to facilitate and promote public participation in environmental governance, that it should be enforced by the state, and that the law should facilitate the enforcement of environmental laws by civil society. These are two incredibly important points, because the first speaks about public participation in environmental governance. And my colleague Matome will reflect in his presentation on how public participation can be at times very difficult, particularly for community organizations. And the second around the enforcement of environmental laws by civil society. This quite important because often civil society is seeing it being at odds with either government departments or corporations which are seeking particular licenses for mining and other activities. And here we really want to say that all aspects of, or all members of these different parts of society are working together to realize environmental governance, and surely should be working together. So those are the kind of initial comments that I wanted to make around the preamble. And if we move into NEMA itself, again, it's almost impossible in the time that we have to go over all the various sections in detail and the provisions in detail, but I'd like to highlight two sections that I think are quite important, and I've set out some other headline sections, but the two important sections here around the principles for environmental decision making, which is section 2. And this applies to to the actions of all state institutions that may significantly affect the environment. And the principles, or the Nema principles, must be considered and serve as guidelines when any decision is made either under Nema or specific environmental management acts, which we will come to. And the importance of these principles have been recognized by our courts. One of the quite, and again, some of these principles reflect what is stated in the preamble. I want to highlight that one of the Nema principles, or two of the Nema principles, specify the role of youth and women in environmental management, which must be recognized, and that a risk-averse and cautious approach must be applied, which takes into account the current limits of knowledge, or the limits of current knowledge and the consequences of decisions and actions. The other key headline section is really around environmental impact assessment and the regime which is created. An EIA requires that potential impact on the environment of certain listed activities be considered, assessed, and reported on to the authorities. And importantly, that environmental authorization is obtained. So it's essential for companies or state institutions to apply for environmental authorization before they start any work on a development that could affect the environment. It's a criminal offense to start with a development without such permission. And there is fines and criminal sanctions that could apply should you kind of proceed without an environmental authorization. And we'll come back to case studies which will really contextualize some of the information that I'm sharing. If we move on to slide 6, what I've done here is just specify the specific Environmental Management Acts, or CMAs. We will focus, and my colleague Nicole will focus on Air Quality and the Waste Act, and Melanie, as she has stated, will focus on other aspects around protected areas and biodiversity. And I think, if we move on to slide 7, it's important to recognize that there are key Nema sections which are applicable to the CMAs, which include, but are certainly not limited in this regard, to the principles in section 2, the legal standing provisions in respect of the range of people who can approach the courts to enforce environmental laws, certain procedural sections on how to appeal a license which has been issued, etc., and sections around compliance and enforcement, criminal sanctions, and appeals. So I've given you a kind of very brief overview in respect of very key sections in Nema and around the CMAs, and I want to hand over to Nicole, who will deal with the Waste Act and provide an example, and also air quality, and also provide an example, and I'll come back to you in respect of the one environmental system. Nicole?
Thanks, Leanne, and thank you for the opportunity, honourable members. My name is Nicole Lawser. I am the head of the Pollution and Climate Change Program at the Centre for Environmental Rights. So a large portion of my work focuses on climate change and air quality from a regulatory and legal perspective, and also quite a bit of it focuses on energy and energy-related issues, particularly coal plants. Yeah, I mean, we could go on for days just talking about the Waste Act or the Air Quality Act. So I'm going to try and give you a very general overview, but I really hope that this will stimulate and encourage maybe further discussions. And if there's anything you would like me to, give it a bit more detail on, I'd be very happy to share any further information or answer any questions. So just in terms of the Waste Act, there we go. So the Waste Act is the first CMA I'll be talking about, but I won't go into too much detail on that. I'd rather spend more time on talking about our practical examples and issues that we see in practice. But just to say that essentially the Waste Act lists a number of waste management activities that would require a waste management license in order to be conducted. It then also imposes a number of obligations and has provisions dealing with, for example, transporting waste, storing waste, treating waste, processing it, and various activities in relation to waste. We have a waste information system online. There it is, SAWIC, as it's fondly known, which incorporates a fair amount of information in relation to waste management licenses and remediation of contaminated land, for example. And then the aspect of the Waste Act that I'd like to spend a bit more time on is Part 8 of the Waste Act, which deals with it sets out a process for the identification and remediation of contaminated land. So the Part 8 process is, I don't want to say fairly new, but it is fairly new to the Waste Act. And what it is essentially is a process where if the owner or holder of land has a suspicion or has reason to believe that their land might be contaminated, they have an obligation to give notice to the department. The minister or the MEC must then notify that person to essentially conduct a site assessment to determine whether or not their land is contaminated. And if the land is found to be contaminated and in need of remediation, then the minister or MEC must issue a remediation order, and that then gets reflected on a national contaminated land register, and it must also be reflected on the title deed of the property. So one example of how we've seen this process or this mechanism play out in practice is in relation to ArcelorMittal, to its Vanderbijl Park steel plant. We've done with partner organizations over the years, we've been quite heavily involved in monitoring ArcelorMittal's air and water pollution, and also keeping an eye on this question of contamination of its site. And in 2015, ArcelorMittal, we refer to it as AMSA, gave notice to the department that its land might be contaminated. So it was required to conduct a site assessment of its land. And I think if anything is going to be taken away in terms of practical issues in relation to this particular aspect of the Waste Act, the biggest issue that we've come across is the lack of timeframes. So in this instance, ArcelorMittal was given notice to conduct a site assessment. It took AMSA 2.5 years to conduct its site assessment. And then some 3 years after it had given this notice that its land might be contaminated, it was found that actually the land is contaminated and it was required to do remediation. I mean, from our perspective, this is highly problematic when you have a provision whose, the objective of this provision is to protect people and the environment from the effects of harmful contamination. And the big problem here is that the Act itself doesn't make any provision for timeframes within which site assessments must be done. So you can effectively have a situation where a polluter is, or an industry is allowed, to take as much time as it needs to conduct a site assessment with little regard for the effects of that contamination on human health and the environment in the interim. And this is a concern we've raised consistently with the department, and the response is generally that this sort of assessment takes a lot of time and it's quite difficult to do, which, fair enough, but we think 3 years is quite an unreasonable amount of time to wait to find out whether or not land is contaminated and having an impact on surrounding communities. And there are a number of communities living right around this particular facility. Another issue was that there was very little transparency in relation to the process. Even now, we don't really know what stage the remediation is at. There's been virtually no communication with surrounding communities in terms of the status of the site assessment and now the remediation. We know that the National Contaminated Land Register is supposed to reflect that, but I just had a look at the register this morning and it's very seldom updated. In fact, the ArcelorMittal plant isn't even on there. And the few sites that are on that register, it simply says remediation. So it doesn't really tell you, how far the process is, or whether it doesn't give communities any means of protecting themselves against potentially harmful contamination. It gives them no information, essentially. So I'll leave it at that on the Waste Act. The next piece of important legislation I would like to talk to you about is the Air Quality Act. Again, I mean, there's a lot we could talk about here, but essentially this piece of legislation establishes a system for managing air quality within South Africa, makes provision for a vast array of mechanisms, including the National Air Quality Management Framework. We also have an online system for gathering and analyzing air quality management information, fondly referred to as SARQUIS. There's the link. It also makes provision for the appointment of officials such as National Air Quality Officer and air quality officers at municipalities. It's mandatory for municipalities to have an air quality officer designated. And then I think I'll just move straight ahead to quite an important mechanism of the Air Quality Act, which is the setting of standards for ambient air quality and then minimum emission standards. So ambient air quality standards are essentially limits or thresholds to limit the risk or threat of harmful air pollutants in the ambient air. So we already have some national ambient air quality standards. The minimum emission standards are air pollutant emission limits that apply to certain activities, listed activities under the Act. So if, for example, if you're going to be operating a solid fuel combustion facility, otherwise known as a coal plant, that is a listed activity for which minimum emission standards apply for the various pollutants that you'll be emitting. And I just want to take a moment here to just emphasize why it is important, crucial really, that we regulate air pollutant emissions in South Africa and globally, in fact. So the World Health Organization has confirmed that air pollution is the world's largest environmental health risk. And there's no dispute that air pollution in many parts of South Africa is well above safe levels. There are regular exceedances of our national ambient air quality standards. All of the evidence for heavily polluted areas such as the Mpumalanga Highveld shows that by far the bulk of pollution is from industrial sources, including coal-fired power stations and mines. And then an independent study that was commissioned in 2017, this is the infographic that you have before you, shows that the air pollution from Eskom's coal plants alone is responsible for 2,200 attributable deaths every year. The impacts of Eskom's air pollution were found by the study to cost us $2.3 billion every year. That's around, I think, 34 billion rand. Eskom itself admits that its air pollution causes over 300 deaths annually. These are not small numbers, and in any event, arguably one death caused by air pollution is too many. So while we have ambient air quality standards and minimum emission standards, these standards are very weak in comparison to World Health Organization guidelines and in comparison to other countries' similar standards. And importantly, the standards that we have are being exceeded. So as I've said, ambient air quality standards are being exceeded in many parts of the country. And we still find ourselves in a situation where some of South Africa's largest industrial polluters like Eskom and Sasol are continuing to push back against meeting these standards. So that's quite an important issue, and I'd be very happy to talk about that in more detail. So then just to continue a bit in terms of the more specific provisions of the Air Quality Act, if you are going to conduct an activity that for which a minimum emission standard has been set, you will also need an atmospheric emission license. Municipalities are tasked under the Air Quality Act with the administration of the atmospheric emission licensing system. So they're essentially responsible for overseeing atmospheric emission licenses. They're the licensing authorities. And then one last important provision of the Air Quality Act that I'm just going to pause on quickly is the provision in the Act, Section 18, which makes provision for the Minister or the MEC to declare an area as a priority area. So the Minister or the MEC can declare a priority area if they have reason to believe that the ambient air quality standards in that particular area are being exceeded, or if they may be exceeded. And then once a priority area has been declared, then an air quality management plan must be prepared and implemented for that particular area. So the Mpumalanga Highveld is one priority area that's quite close to our heart, although maybe I should just quickly say that there are currently 3 declared priority areas, the Vaal Triangle, the Mpumalanga Highveld, and the Waterberg. So the Mpumalanga Highveld was declared a priority area in 2007, more than a decade ago. It is home to 12 of Eskom's coal-fired power stations, Sasol refinery, Synfuels coal-to-liquids plant, and then hundreds of other industrial facilities and mines. As many of you probably already know, this area is highly polluted. And despite the fact that it was declared a priority area more than 10 years ago, we have seen no substantial improvement of the air quality in the area, despite the fact that there is, in fact, an air quality management plan for the area. So the fact is that the ambient air pollution levels in the Highveld are dangerous, and that people living and working in these areas breathing ambient air that is harmful to their health and well-being every day. So in 2019, the Centre for Environmental Rights, on behalf of Groundwork and the Vokani Environmental Justice Movement in Action, launched litigation against the Minister of Environment, the National Air Quality Officer, the President, and a number of other government officials, essentially in relation to the fact that the ambient air, essentially in relation to the fact that the air quality in the Highveld is unacceptable and causing harm to people's constitutional rights, essentially. And what we've asked for there in this litigation, or through this litigation, is a declaratory order that the poor air quality in the Highveld priority area is in breach of people's Section 24A right to an environment that is not harmful to their health and well-being. And we are also asking the court to compel the proper enforcement of the area's air quality management plan through implementation regulations. This case will be heading to court in May, the 17th and 19th of May. And I should probably also just mention that the UN Special Rapporteur for Human Rights and the Environment, Professor David Boyd, is an amicus curiae, a friend of the court in the case, and he'll be making submissions specifically on the adverse effects of air pollution on the enjoyment of human rights and the obligations of states under international human rights law to address the harmful effects of air pollution. Okay, and then just finally, it's difficult to not really talk about, it's difficult to leave out, rather, the regulation of climate change under South Africa's legal environmental law regime. Currently, the few pieces of climate-related laws that we have are housed and sitting under the Air Quality Act. So those, we have 3 sets of regulations. The first is the National Greenhouse Gas Reporting Regulations that essentially places an obligation on emitters who exceed a certain threshold to report their greenhouse gas emissions annually. And then also under the Declaration of Greenhouse Gases as Priority Pollutants and under the Pollution Prevention Plan regulations, emitters who exceed a certain threshold are required to submit pollution prevention plans. These plans are supposed to cover a 5-year period and set out how these emitters plan to reduce their emissions over that 5-year period. These are all voluntary commitments. There are no legislated greenhouse gas emission limits. So companies are purely meant to set out in a plan how they plan to reduce their emissions over a 5-year period, and they're supposed to report against those plans every year. So as you can probably see, we are somewhat lacking in terms of a robust piece of legislation that can adequately regulate the broad and very significant issue that is the climate crisis. At the moment, we have a climate change bill. It was published for comment in 2018, and now more than 2 years later, we still have not seen the Climate Change Act promulgated. And this is important because we have a national policy that recognizes that South Africa as a country is extremely vulnerable to the effects of climate change. The UN recognizes that South Africa is a climate hotspot. It's going to get a lot hotter and a lot drier. And this is going to result in catastrophic consequences for the people of South Africa and numerous constitutional human rights violations. In addition, South Africa is also a significant greenhouse gas emitter. So while we are vulnerable to the impact of the climate crisis, we are also contributing to the impact of the climate crisis. South Africa is the 13th largest greenhouse gas emitter. So while it's an international obligation that we reduce our greenhouse gas emissions, it is also a constitutional imperative. And for that reason, it's very important that we, as soon as possible, get proper climate change regulation through legislation in place, and that those regulations start to take effect very soon, given the urgency of the situation. So I will leave it at that, I think. Thank you very much. I think, is it over to you now, Leanne?
Yes, thanks, Nicole. Okay, so moving from climate impacts, waste and air quality into mining, and I'd like to explain a little bit about the One Environmental System. And it's a very brief explanation because I would like to focus on the example on mining on the West Coast. So the One Environmental System came into effect through a series of amendments to various laws in about 2014. And the important thing to bear in mind here is that a NEMA environmental authorization is now required for mining. So this was previously regulated separately under the MPRDA, but it's still administered this and decided and compliance measures also taken and enforced by the Department of Mineral Resources. However, appeals to decisions taken by the mining minister, for example, goes to the environment minister. So that's a really important distinction or thing to note in respect of the One Environmental System. And it really relies on quite close cooperation between departments in order for the system to work properly. And I want to move on to describe a case that we're working on at the moment, which illustrates some of the difficulties in the One Environmental System. If we can move to slide 18, which is really just, kind of raising the question here on whether or not the One Environmental System supports rational decision-making and decision-making that is based on the NEMA principles. And I want to speak about the case of Tormin. So we're looking here at sand mining along the West Coast by an Australian mining company. And important, for a little bit of context to say that this particular company had a history of non-compliance in respect of environmental regulation. It paid a fine in terms of Section 24G for non-compliance or for commencing activities without a prior authorization. It was about a 1.25 million rand fine. This is the same company that launched a series of slap suits against activists, particularly environmental activists opposed to mining along the West Coast and raising critical issues on environmental degradation caused by this mine. And
Leanne, are you still there?
Yes. Are you
Okay,
not able to speak?
we just lost you for a few minutes, so just come back. Yes, thank you.
Oh gosh, sorry about that. It's probably load shedding in my area. So it's important to note here that an environmental authorization was granted by the mining minister for the extension of this particular mine. So mining had already commenced, and the company had sought an environmental authorization for the extension of the mine. We appealed against this particular environmental authorization, raising the Nema principles, citing the fact that this mine is located in a critical biodiversity area, and importantly, cumulative impacts had not been assessed in this particular environmental authorization. We also raised issues in respect of the interrelationship between the granting of the environmental authorization and Section 102 of the MPRDA, which allows companies to apply for an amendment of their mining right. And I'll come back to that issue in a second. So the environmental authorization was granted by the mining minister. We then appealed against this decision, or the mining minister or the delegated authority, we appealed against this decision to the environment minister, who then dismissed our appeal. And currently we are reviewing the decision of the environment minister to dismiss our appeal against the environmental authorization. Again, we're looking at issues around whether or not proper consideration was had for the range of things that we'd raised around the Nema principles, cumulative impacts, and whether or not all factors or relevant factors were considered by the environment minister in taking that particular decision. Importantly, the environment minister took the decision to dismiss
Leanne, we lost you again. Is this load shedding happening on your side? I know you warned this.
Sorry about that.
That's okay. Just start with, you said the environmental minister took the decision and then we lost you.
Okay, so it's important to note that the environment minister took the decision to dismiss our appeal against the environmental authorization before the DMR had decided on the extension of the mining right. So essentially, there was a decision on environmental authorization before, and that decision was taken and the appeal decided before the 102 application on the extension of the mining right was taken. So you can see then that, you know, there hasn't really been proper coordination environmental authorization for the mine extension. So that's what's happening right now in terms of the current review application. And this raises several issues, right? It raises issues around cooperation between departments.
Leanne, I think we lost you again.
Gosh, maybe I should just stop there and I'll come back to the challenges related to the One Environmental System at the end of my presentation, or at the end of our presentation, and I'll hand over to Matome.
Thank you, Matome. You can go ahead.
Yeah, thanks.
Just remind you, remember to introduce yourself.
Yes, thanks, Melanie. Yes, my name is Matume Gaba. I'm an attorney and I head the Activist Support and Training Program at the Center for Environmental Rights. The work that we do in the program mainly entails providing training, providing other legal support to communities that are affected by mining and other polluting industries. And then in this bit of the presentation, I'll just be speaking about some challenges that we experience or challenges that affected communities are experiencing when dealing with this particular pieces of legislation that we were talking about. Let me start with the public participation processes. So much of the legislation that we are discussing provides for licensing and authorization processes for these industries before they can commence. And these licensing and authorization processes include an aspect of public participation. And this is an opportunity for communities to give their inputs, to give their comments about the proposed operations, how it will impact on their health, how it will impact on their well-being, and how it will impact on their livelihoods. Now, a big challenges for affected communities during these processes is that, one, they struggle to gain access to important documentation and information regarding these proposed operations in order for them to be able to make meaningful contributions to the process as a whole. So that's the first issue. And then the second issue is where communities are able to obtain such documentation. These documents are often highly technical. They require a varying expertise to decipher, and communities do not receive any technical or other support in translating or processing the data that is in these documents, and therefore communities go into these public participation processes at a disadvantage already because they do not have the full extent, they do not have an understanding of the full extent of the proposed operations as a whole. The other issue that also troubles affected communities is that while they don't have experts assisting them with the technical data that is in these applications, mining companies or polluting industries have employed scientists and other experts who assist them with the applications. These experts are termed the environmental assessment practitioners, or EAPs. And there are two issues with these EAPs. One, it's the obvious impartiality challenge of EAPs because they have been employed by the polluting industry. Therefore, they need to fulfill the mandate of their employer. So that's number one. And then number two, there is an information and expertise imbalance in favor of industries, being that industries are the ones who have all the experts, all the scientists, and then communities do not have the access to these, and therefore communities have to rely on the experts and scientists employed by industry to translate and to provide them with the full extent of the impact of the proposed operations. So this is an aspect of this that makes public participation for affected communities difficult. And then after public participation, there is usually a process where communities are able to object to the proposed operation or even appeal some of the licenses or authorizations that have been issued. However, the provisions in law regarding these objections and this appeal do not seem to have been crafted with poor communities in mind because one, there is the issue of the appeal and objection timeframes being short, so communities do not have enough time to consider all the information and in order to make substantive objections to the operations. In addition to that, the amount of technical and scientific data that is required to make these objections and to make these appeals is too much. It's a lot, it's voluminous. And remember that most affected communities do not have access to technical experts to assist them with reading, translating, and processing this data. So the amount of work that is required to make an objection or to have a license or an authorization that is to be set aside by a court of law is simply unrealistic for pure communities because it involves reams and reams of paperwork, which obviously attract high legal costs. So a solution that has been, that civil society has been pushing or engaging with Parliament and government in relation to that might lessen the burden on affected communities is the principle of free, prior, and informed consent. You might have seen the campaign on social media where people are speaking about communities' right to say no. In principle, this would require industries to obtain the consent of people who will be affected by their operations before they can build their operations. So people who will be affected by these operations would have to say, yes, you can come and build here. And while this principle itself is not perfect, but it has the potential to shift the imbalance of power in favor of affected communities, because now affected communities would be able to use their right to say no, to be able to negotiate better circumstances for the operations. Not only that, but they will be able to negotiate for access to these, access to better understanding of how the operations are going to impact them. They will be able to negotiate better, so they will be able to negotiate for independent expertise to come and analyze and process a lot of this data around the operation, so that communities can have full understanding of the operations before they make a decision. The next aspect of some of the issues that I would like us to deal with is in relation to compliance monitoring and enforcement. So this is when the operations is up and running, and now communities need to ensure that, or there needs to be, we need to ensure that now that industry is complying with its legal obligations. So the first issue again is access to important information and documentation. So there has been significant improvements in the law and in legal practice regarding how affected communities may access licenses, authorizations, and application and other important documents. However, these documents still remain inaccessible to communities because, one, there is some resistance from government to freely provide these documents. There is resistance from industry officials to freely provide these documents. These are things that are still in process. And this resistance, then, that means that affected communities have to resort to complex and sometimes tedious legal processes, such as PIA, to gain access to the documentation, therefore diverting their attention from dealing with the actual impacts of what the operations is having on their health, on their well-being, on their livelihoods, and so on. And even in instances where communities manage to gain access to these important documents and information, there is still the challenge that the information is provided in an inaccessible manner. So it will be reams and reams of paper that require experts and scientists to translate and to process, so that people can be able to decipher what the legal obligations are and what are the implications for their health, for their well-being, and for their livelihoods. So most of the time, it means that communities are either not aware of the legal obligations of industries that are operating in their backyards, and if they are not aware of the legal obligations, they are unable to report non-compliance. Another issue in relation to compliance enforcement and monitoring is that government is simply not present in affected communities to teach communities about reporting mechanisms. So communities have to figure themselves out, have to figure out how to report environmental violations. And where communities do figure out there is some unwillingness from government officials to take strict enforcement measures against industry. There is always a position to lean towards giving industries second chance after second chance to self-correct. So industries will be made aware that you are not in compliance with certain obligations of your license or of your authorization, can you please take measures to correct this instead of taking strict enforcement measures? And also something that my colleague Nicole also touched on is in relation to that the provisions of compliance, monitoring and enforcement in law, they rely too much on criminal prosecution. Criminal prosecution has a much higher burden of proof threshold and often results in penalties that do not disincentivize non-compliance. And something that the Center for Environmental Rights has been advocating for some time is the implementation of administrative penalties, which would be a better and easier alternative. Also, affected communities always provide that they are best placed to be non-compliance monitors of operations that operate in their backyards, because they live there with the operations, they're able to see the day-to-day happenings of these operations. However, affected communities are neither empowered enough to be able to monitor compliance, or they are not provided sufficient access to government inspectors. For example, communities report that they would report what they suspect is non-compliances with the law. And then what happens is government inspectors take too long to respond to their reports, and where government inspectors are reporting or they're coming to come and inspect, do inspections on the operations, industries are given extensive notice periods prior to this inspection to allow them to put their affairs in order before they get a visit from the inspector. And one last thing in relation to compliance monitoring and enforcement. Some years back, the Center for Environmental Rights conducted an investigation in relation to the capacity of government's capacity to conduct inspections on polluting industry operations. And what this investigation came out, we released a report called 0 Hour. And the report reveals that there isn't enough capacity in government itself to conduct monitoring, to conduct effective monitoring and enforcement of non-compliances. We have also followed up the findings of that report most recently last year. We did some follow-up records just to find out if there has been an increase in capacity since we last released the 0 Hour report. And what we found is that capacity is still something that is not enough. That's something that requires attention. And then lastly, I just want to speak to the situation of threats, intimidation, and violence of environmental activists in affected communities. Because when environmental activists do finally report non-compliances with the law of polluting industries and how they affect their health, their well-being, and their livelihoods, they are often, the response is usually they get threats, they get intimidation, they get violence. I would like mention here of the cases of, for example, Comrade Basuka Khadebe from Amampondoland, and most recently, Umamfingile Nchangase in rural Tuba KZN, whose murders are still unsolved, and what they were doing is trying to report non-compliances or failure to comply with the law by industry. And while industry players are always quick to remove themselves or divorce themselves from these occurrences to say, these incidences have nothing to do with us as a company, and then they state their principles, it is undoubtedly true that industries create circumstances that lead to these incidences. One, in that if there was no non-compliances with the law that environmental activists need to report, there wouldn't be these circumstances. And then two, also industries, especially mining, the mining industry itself, it always creates an environment of division amongst community members in terms of who benefits, who does not benefit. And this is also an element that breeds this animosity against activists who report non-compliances with the law against these industries. Thank you. I will end it there. Once again, thanks, honorable members, for having us. And thanks, Melanie.
Let me just see, Leanne, are you circling back quickly with the challenges? We can just round up quickly.
Okay, let me do that. And I think Matome's done kind of really well at covering the second slide that I had on the challenges. So I will focus just on the slide 19, which is really about the first challenge on kind of not curbing the excesses or the impacts, you know, that companies bring about in terms of their operations. And so very rarely have we seen environmental authorizations that have not been granted, or mining permits that have not been granted pursuant to the authorization. And, you know, just today, I think there was a release that, a press release around the Limpopo Environment Department having commented on a specific environmental impact assessment, and having said that communities were not consulted properly in terms of you know, only using English to share information, and some of the challenges that Matome has raised, and importantly highlighting how the alternatives to that particular development were not properly considered, and asking that the EIA actually be looked at again in terms of those particular issues. So that is unfortunately not something that happens very often, but it is something that I think needs to be considered quite carefully. Around the One Environmental System, I've raised some of the issues around just the uncertainty between different pieces of legislation and the applicability and cooperation amongst the departments, but also around compliance enforcement. There's a massive issue here. You know, and really around the One Environmental System, we need to think very carefully around whether it's working properly, and what are the things that could be done in order to ensure streamlining. Cumulative impacts, again, something that is a massive issue right now along the West Coast. If the for operations that are south of current operations, it will mine about 65 kilometers of pristine West Coast. And so there's a consideration that needs to be had on whether or not the regional impact of that mining has been considered, because this company has done its applications in a very piecemeal fashion. And I think you know, just on how we are streamlining various pieces of legislation to address the climate crisis, it's not clear that we are taking provisions that will address issues around climate change. And finally, on decision makers ignoring the advice of their own scientific authorities. Again, in the Torman matter, you had regional scientific authorities make comments during the EIA process that raised issues around critical biodiversity, that opposed the environmental authorization, but still the authorization was granted. And it's a question of, if you have Cape Nature or Sanby or any of these institutions that are commenting during EIA processes, how are these comments being taken into account and addressed? And yeah, I'd like to conclude there and say, you know, it would be great to just continue the conversation. There's a lot that's been unpacked, and we really do thank you for this opportunity to present to you today.
Thank you, CR. Honourable members, we will give you all this presentation. I know this is getting long, but we just want to circle back to Melanie Mercat, Dr. Melanie Mercat, who's just going to briefly talk about Biodiversity Act, which is, of course, we haven't quite touched the animal and the plants yet. So she's just going to talk to you about that, and then we'll open up for questions and answers. So just note all your questions and answers. Your questions, please. Thank you, Dr. Mercat.
Thanks, and I'll try and be brief because I know there's been a lot of information so far. So there are really 3 key pieces of law that address biodiversity, conservation, and protection of habitats, and those are NEMBA, the National Environmental Management Biodiversity Act, NEMPA, the National Environmental Management Protected Areas Act, and then the National Heritage Resources Act. And I'm going to discuss them very briefly. The slides have some of the highlights of the laws, but it's worth contextualizing each of them. If there's one thing that I would like honorable members to take away from the presentation today, is that all of the systems that make up the environment are interconnected. So mining laws are very much interrelated with biodiversity laws. Hopefully that came through from Leanne's presentation, that if mining is approved in high value conservation areas, that impacts biodiversity, and it impacts Earth system functioning, and it impacts us all. So I think that's a really key takeaway, if nothing else, from this part of the presentation. So NEMBA was enacted to protect biodiversity, and to know what that means, it's useful to understand the definition of biodiversity in the Act, which is the variability among living organisms from all sources, including terrestrial, marine, and aquatic ecosystems, and the ecological complexes of which they are a part. It includes diversity within species, between species, and of ecosystems. So what that tells us is that biodiversity is everywhere. I'm sure there's biodiversity in each of the rooms you find yourselves currently. I'm sure that there are ants, that there are, hopefully not, but perhaps cockroaches, perhaps moths, perhaps mosquitoes. And to paraphrase the renowned Kenyan environmental activist Wangari Maathai, the food we eat, the water we drink, and the air we breathe are all a function of biodiversity. So biodiversity is not only something to be found in national parks and to be protected in those spaces, but also it is everywhere. And despite the many threats to biodiversity in South Africa, we continue to be very rich in biodiversity. So although we make up only about 2% of the world's land surface, we have the 3rd highest levels of biodiversity in the world. And in order to conserve biodiversity, NEMBA interestingly adopts a sustainable use approach to the protection of biodiversity. The phrase sustainable use, or at least the phrase sustainable in relation to the use of a biological resource, means, in terms of NEMBA, the use of a resource in a way and at a rate that would not lead to its long-term decline, not disrupt the ecological integrity of the ecosystem in which it occurs, would ensure its continued use to meet the needs and aspirations of present and future generations of people. So that's the paradigm of the biodiversity conservation law that we have. And this approach means that activities like hunting and culling, for instance, are permissible under the law, but under certain conditions and in ways that are controlled. And there's a lot of questions about and controversy about whether this is an appropriate approach. And that's really something to think about. And also whether the sustainable use paradigm that's envisaged in the Act is being pursued, or whether another version of sustainable use is being pursued. So there's a lot of use that is arguably not consistent with ecological integrity. And there's a lot of use that perhaps doesn't respect the aspirations of present and future generations of people. And so those are implementation problems that are really worth thinking about. So what are some of the highlights then of the Act, or main features of the Act with respect to that introduction? So the Act aims to ensure the management and conservation of biodiversity, give effect to various international instruments aimed at biodiversity conservation and use, ensure sustainable use of biodiversity, as I've explained, and create the South African National Biodiversity Institute that Leanne just spoke about. And then to pursue these goals, we have a system of listing ecosystems and species that require protection and categorizing those species into different categories, so either critically endangered, vulnerable, or protected, and then allowing use depending on their categorization. And hopefully you can immediately see a problem there, a problem that when we single out species, we fail to acknowledge cumulative impacts and the interrelations among species. And so that system of categorization perhaps undermines the ecosystem approach that the Act hopes to achieve. Then you've got provisions aimed at permitting the commercial or industrial exploitation of indigenous natural resources. You've got parts of the Act that restrict activities and require permits, specifically relating to alien and invasive species, which are one of the key threats to biodiversity in South Africa. And then you've got Chapter 7, which deals in more detail with permitting and imposes criminal offenses. And of course, we have implementation problems with permitting. We often don't see the right conditions being included in permits, and we have under-resourced provincial authorities who are largely responsible for permits. Then just a few other highlights of NEMBA is that it envisages the creation of various regulatory tools, such as the National Biodiversity Framework, and norms and standards and regulations that really supplement it and give it content. The National Biodiversity Framework recognizes and seeks to respond to some of the major pressures on biodiversity, including climate change. But what we don't see in the Act is a recognition of the relationship between climate change and biodiversity loss. And that's obviously because the Act is relatively old. On the hierarchy slide, I put all the times of the different laws. And so we perhaps need to relook at all of our environmental legislation to see in what ways should climate change issues be integrated into the laws. Then we also see powers of SANBI. SANBI has a very important role to advise the minister, to engage in consultation, and then to manage and control certain aspects of biodiversity in South Africa, including our botanical gardens. Then moving on to NEMBA, NEMPA, the Protected Areas legislation, must be understood with reference to South Africa's problematic history of protected areas. So I'm sure we'll appreciate that when the apartheid government designated areas for conservation, and even colonial authorities before that, there were no detailed plans considering high-value conservation areas, and instead protected areas were established in a relatively ad hoc manner, characterized by forced removals and exclusion of the majority of South Africa's population. And this legacy lives on to a great degree. We have, for example, the Game Theft Act, which effectively incentivizes largely white landowners to fence off their protected areas, to fence off conservation areas for purposes of conserving biodiversity. But science tells us that biodiversity needs to move. And so legislation that incentivizes fencing off is problematic. We need corridors for biodiversity to move and for protected areas to flourish. Protected areas and the things in them, the plants and animals in them, are not static. They change, and water changes, and all the systems around them change. So that's one of the regulatory challenges there, that interaction between NEMPA and the Game Theft Act. But of course, there are advantages to fencing and reasons for fencing, but those issues shouldn't be looked at in isolation. We should always keep in mind the bigger picture, the systems that we're trying to protect, and our interrelationship with those systems. One of the problems, of course, of the past is that ecological boundaries were seldom considered, and instead protected areas were established based on administrative boundaries. And many protected areas, as a result, are isolated. They don't have connectivity to other ecosystems around them. And this limits movement that would support natural systems. NEMPA does attempt to respond to some of these problems. And NEMPA, I would say, is particularly important in a time of climate change, not least because protected areas act as carbon sinks. So they help us have oxygen, to put it very simplistically. Maintaining protected areas is really an important part of carbon management in an era of climate change. And again, this isn't directly reflected in NEMPA, and perhaps that's something that needs to be revisited in terms of integrating climate change issues into the scheme of environmental law. And protected areas, of course, important community resources. They have vital tourism roles, as well as bringing in, as well as significant cultural value. And so I've just summarized some of the important purposes of protected areas, which is also to ensure protection of biodiversity. So hopefully you see the link with NEMPA. And the explicit goal of involving local communities is articulated and not, I would say, adequately pursued in its implementation. And then there's, of course, the goal to provide for the continued existence of national parks. So in NEMPA, importantly, the state is established as the public trustee of protected areas for the benefit of all South Africans and all people in South Africa. And then we have Chapter 2, which is really the mechanics of the Act. It tells us how different areas will be classified depending on their significance and their conservation value. And then there are restrictions on the areas which are linked to the classification. So Chapter 3 tells us the various purposes of the areas depending on their classification, as I've said, and also highlights that the reason for protected areas is to preserve ecological integrity, but also permit use. Then we have provisions that allow for withdrawing or amending protected area status. And of course, these are important because we need to, because of the way in which protected areas were originally established, there is a need to revisit some of the areas and perhaps enhance to a great degree the areas. And there have been some movements within the Department of Environmental Affairs to do that. But there's a problematic side to this, which is to withdraw protected area status so as to permit things like mining in those areas. And one of the issues that is raised in the Mabola protected area litigation that's currently ongoing is that a protected environment status has been withdrawn merely by publication in the Government Gazette. Other protected areas have to be, or other classifications of protected areas have to be withdrawn by way of even a special resolution or an ordinary resolution of Parliament. But a simple Government Gazette has taken away Mabola's status, and this is something that we can be at least critical of or ask questions about. Then there are various sections that impose limitations on use and access to protected areas. So things like you need a permit to go into a national park, you can't hunt without getting the relevant permits, you can't bring things in, you can't mine without certain procedures that must be followed. So those are some of the highlights of the Act. And then of course there are criminal offenses that are imposed when there's violations of those restrictions. Then very lastly, the Heritage Resources Act. This act is important because cultural aspects of the environment form part of the environment that emerge from the definition of the environment that I began with at the start of this discussion. And the National Heritage Resources Act is best understood with reference to its preamble, which tells us, among other things, that our heritage is unique and precious and cannot be renewed. It helps us define our cultural identity and lies at the heart of our spiritual well-being and has power to build our nation. Now, all of that speaks to the intrinsic value of the environment where the heritage that this act speaks to is found. And so some of the key goals of the Heritage Act are spelt out here. And then some of the important sections are that the Act establishes a national estate, which includes heritage resources and can be places, buildings, objects, historical settlements, and landscapes of cultural significance. So we can see that there's a link between heritage as landscape and heritage as objects, and protected areas and biodiversity, because much of our heritage is found in protected areas and is found in biodiversity. Then there are heritage principles, including one that I've highlighted, that every generation has the moral responsibility to act as trustee of the national heritage for future generations. So a kind of departure we see from colonial thinking about the individual and a shift towards a decolonizing environmental law where we think of ourselves as bearing responsibility for future generations. So a nice move away from individual thinking around protection of the environment encaptured in Section 5 of the Heritage Resources Act. And then we have a system for grading places and objects, and the grading is directly linked to how much protection is afforded as well as who is responsible for the protection. So the more significant the heritage resource, the higher the level of protection afforded, and the broader the responsibility. So a national government is responsible for the most significant heritage resources, and so on. And then lastly, we have, of course, there is a lot more in all of these laws, but lastly, we have the creation of the South African Heritage Resources Agency, and its powers and functions are spelt out. I have a very brief list of what does and doesn't work. So I've highlighted that there's this idea of ecological sustainability, but we haven't given much thought as to what it means and what it should mean and how it can be operationalized through our law. A lot of academic commentators comment that what this mandate should mean is strong sustainability, seeking to retain ecosystem services and natural capital for humanity, and also recognizing the ways in which human existence and protection of the environment are intertwined, rather than treating only humans as worthy of legal protection and the environment as purely instrumental. So that's one of the critiques of the law overall. Then I would say one of the underutilized resources is the environmental justice principles that emerge from Nema that address distributional issues in environmental implementation. Another problem specific to biodiversity law is that because protection of biodiversity is so dynamic, the law needs to be updated all the time. But our regulations dealing with threatened and protected species haven't been updated and are a bit out of date. We also have undercapacitated provincial permitting authorities, an increasing recognition of animal welfare concerns not being adequately addressed by environmental legislation, and then the Department of Environmental Affairs viewing these concerns as falling outside of their mandate, which became very obvious in recent litigation about captive breeding of lions and the lion bone trade. And then, as I've already mentioned, there are concerns around withdrawal of protected area status without full consideration of issues of ecological integrity and also the overarching constitutional mandate of ecological sustainability. So those are some of the things that don't work. Thanks very much.
Thank you very, very much. Honourable members, I know that was a big mouthful. There was a lot happening there. But I do want to give the opportunity, and I also know it's close to lunchtime, but I do want to give the opportunity for some questions and hopefully or comments, whatever suits you. So if you can just indicate to me, I know we've had to lose a couple of people because they warned beforehand they had to go. Let me see if there is anybody who's putting their hands up. Just let me know.
Melanie, it's Anne-Marie.
Yes, sure. Go on, Anne-Marie.
I don't particularly want to ask questions now because it's a history and things that goes around it that needs to explanations and examples. But my question or my request is to the gentlemen and the ladies that's on here. I know it is a big request, but if we maybe can have their contact details in the sense that if we, I live in Mpumalanga, I live in Middelburg, I live close to eMalahleni, so I follow the case of groundwork and CR quite closely. But when we have serious questions or things that maybe if they would be willing to share the information with me, I will not give it out, but I know you are very protected about your information. If we run into trouble, like Kendall is 40 kilometers from me, which is, you know, working with equality, a major problem. So, you know, maybe in an advisory thing, I can appreciate that if possible. Thank you. And thank you very much for the presentation.
My guess is that they don't have a problem with work emails, I would guess. Is that okay? Is that fine? I'm looking at the executive director of CER nodding her head, so I'm guessing that's okay. So we will let you have that. Okay, I will do that. Anybody else? Honorable Mbata, no questions today? No?
No, I just want to understand, because these are critical laws that we must understand, especially when we're dealing with environmental, with both environmental department, portfolio committee and agriculture, because in both of them, including the mine, minerals and energy, these are very important. But it's just that today you had too many information. I'm fortunate because it's one of the studies that I'm doing with Northwest University, but I'm just thinking for my colleagues that they need an in-depth information on these issues, because when I listen, especially on the authorization, where there's no working together between the Minister of Environment and the Minister of Minerals and Energy, I find it very, very sad, because at the end, what is important is the rights of the communities, and of which, if those rights, like Section 24 clearly states, and if those rights are not adhered to, it is a problem. I remember I raised the issue of my area, because where I'm staying, we are nearer to the industrial areas. One of them is in Assetima, the one in Vanderbilt Park we have here. There's a lot of industries. And again, if you look at the one in Durban, the engine one, where there was a fire, when you are around that area, there's a smoke, there's a smell. You can smell the air pollutants, that the area is contaminated. But if our government is not assisting us, because if you look at the environmental management inspectors, they say they are understaffed. And in other municipalities, we don't have the EMI. Like in Tshwane, we don't have the EMIs, but in other municipalities, they have. And then you see that there's no collaboration of these three spheres of government, because once there's something here at national, they develop policies and everything, but implementation is done by the province, and the most ones is the municipalities. And if the municipalities are not empowered, it becomes a serious problem. And lastly, there was that pollution from Mpumalanga, which came all the way from Mpumalanga because of the wind up to Pretoria. And you know, if you look at how sometimes these people, the owner of these companies, they drag their feet. It's very painful. It's like, yes, we have policies, but we are toothless. We can't put into task these people so that they comply. In other countries, the compliance is very strict. I don't know why in South Africa, why we are so lenient to the perpetrators. And I'm happy when you say, when the Matume says on the issue of public participation, you know, the public participation will come in your area and you won't know because they are hiding it. And the worst point of it, it's in English. And most of the communities, we find that they don't understand the English. They don't understand what is the public participation, what is it for, and how is it going to affect them at the end. They are ignorant, and that's where we need to do. I'm happy there's NGOs like Greenpeace who are trying to empower the communities. That's why we need to empower communities, and also look at those that cannot read and write, to say how best can we assist them so that they understand the danger of these things. And where's this nowadays, you find the landfill site that is nearer to the residential area. And before, the residential, I mean, the landfill site was not supposed to be nearer the residential area, because all those air pollution and air pollutants, they go to the nearby communities. It's very painful. I wish we can have people like Greenpeace and others who can be the eye and the ears of the disadvantaged and the poor communities, because they are being taken for granted, and it's very painful. Thank you.
Thank you, Honorable Mbata. And I think most probably if I sent you the contact details also from the people from CER, because they also do a lot of this work. I know that they often act on behalf of communities. I'm going to just give Honorable Bryant a chance to raise his questions or comments as well. And then we can maybe round up at the end with everybody saying, you know, just giving their answers or comments on what was just said. Honorable Bryant, do you want to go ahead?
Yeah, thanks very much, Melanie, and thanks for the presentation to all of the presenters. I think it was quite interesting and quite insightful to see the CER's perspective on the legislation and, you know, their particular framing of certain issues. And I think it's really important for us to get as many different perspectives as possible on the legislation so that we can make, you know, objective decisions and have sort of a wide range of considered input going forward. I think this is just more a comment than a question, but really, no, I think two things for me. The one is the importance that we place on the protection of the environment versus the importance that we place on the quality of life of human beings going forward. And I think, I mean, it's a very big, broad statement to make. But particularly now coming out of the COVID lockdowns, the number of people who are currently unemployed, the serious levels of economic and environmental and municipal degradation across the country. and the impact that's having on human communities, and the pressure that I think we're going to be under to make certain allowances in order to effectively help people survive the next few years, which are going to be very, very difficult time for many reasons. The other point that I would like to make is in terms of public participation, and I think this is a very important issue in as much as communities surrounding some of these environmental or these environmentally controversial hotspots are often manipulated either by one vested interest or another, either directly via corporate funding or potentially via corporate funding through a foundation or through some other way to effectively ensure compliance from surrounding communities, one way or the other, either to argue for one point or the other point. And I think what we're really angling for, and I think what our national legislation and the Constitution aims to do with public participation, is to ensure that what we're getting from communities is actually what the communities want, what the people want, and not necessarily what vested interests want. And I think that's a kind of central aspect of making any of these projects work going forward. So I hope that wasn't too airy-fairy and broad, but it's just my thoughts on the matter. And thanks again to all the presenters for the presentations.
Thank you very much. I think those were all the questions. Am I right? There's nobody dying to ask a question. So I'm just going to get back to you guys. Who wants to say something on this? Can I just see? Nicole, did you want to mention something on the air? No?
I'll let Leanne go first.
Who's going to go first?
I'll go first, Melanie. I wanted to just touch on the comments that Honourable Bryant was making around the kind of perception that, economic recovery is somehow at odds with environmental protection, because I think they're not mutually exclusive and they can be achieved. And this is why, the CER and a host of other organizations are specifically focused on how public finance, apologies about the noises here, on how public finance can be used for development that is not kind of carbon intensive. And so that, I think, is an incredibly important thing to reflect on, because where the private banks in particular have pulled out their funding for very carbon intensive projects and that cause environmental degradation, state institutions are increasingly funding in the sphere. And so we really, I think that there's a huge opportunity for this committee and other committees to be able to have oversight in respect of that funding and ensure that any development projects are looked at in terms of alternatives to carbon intensive projects, which are very much possible.
Thank you. Melanie, you want to say something?
Yeah, I think it follows nicely on from Leanne's comment is that in any response to COVID-19, it should be acknowledged that zoonosis like COVID-19 is not a result of chance, and that there's strong scientific evidence that ecological changes have increased the rates of emerging and re-emerging diseases like malaria and other diseases that we see, Ebola, and COVID is one of these. And so we have to acknowledge that human activity is increasingly disrupting the Earth's natural systems, and that that's causing us to suffer. And so the kinds of responses that Leanne was speaking about should be incentivized by that ecological reality and its socio-ecological realities or implications for people, especially the poor.
Thank you. Matomi, I saw your hand was up. Did you want to say something?
Yeah, I just wanted to add something around. I think there is a huge missed opportunity on the part of government on not empowering affected communities to be able to properly participate in environmental governance. One, I think if affected communities were to have sufficient and accurate information about operation, they would be able to give inputs that would ensure that if operations do go ahead, that the operations would produce optimally. That's number one. And also, in terms of compliance monitoring and enforcement, if communities are empowered to be able to monitor legal obligations of industry, communities are best placed to do this because they live next to these operations. So I think there should be some consideration towards capacity building and building that trust relationship between affected communities and government compliance enforcement officials in relation to some of these polluting industries.
Thank you, Matome. Nicole, did you still want to say something, or are you good?
I'm good. Sorry, there's some noise in the background, so I actually probably I don't need to say much. I think my colleagues have covered everything, but just to add, I mean, I think it's really important to emphasize this question of the risks that we expose ourselves to as a country financially and economically by, subsidizing and sinking money into harmful fossil fuel investments or projects that are likely to become stranded assets in the future. So as Leanne said, it shouldn't really be a trade-off between economic development and a clean carbon-friendly trajectory. Those are presently synonymous, and we're exposing ourselves as a country to huge economic transition, or they call it transition risk, essentially by failing to take action sooner rather than later to transition our entire, I want to say electricity system, but it also goes broader than that. So I'll leave it at that, but I see Honourable Bryant has a hand up.
Do you want to say something in response, Honourable Bryant?
Yeah, it's not actually in response to that. I think all those points are great. The thing that I'd like to raise, and I'd just like to put it out there and just see what the panel, so to speak, would like to add anything on it. But I know the Spatial Planning and Land Use Management Act was mentioned earlier, and I sat in the portfolio for environment and spatial planning at the City of Cape Town when it came through. I remember some of the input that we put through at the time was regarding specifically the public participation aspect, in as much as the municipal planning tribunals, establishment of the municipal planning tribunals, which was then enforced across the country. And I know previously in Cape Town we had a sub-council system. We still have a sub-council system, but the sub-council system used to make those decisions in terms of planning applications. And that was effectively made up by a panel of local political leaders, your ward councillors, and one or two PL councillors who would sit on those decision-making committees. That's now been replaced by this Municipal Planning Tribunal. And the Municipal Planning Tribunal is a group of unelected representatives who are put in place by the administration. No politicians are allowed to sit on those municipal planning tribunals. And I think when it first came in, it was quite broadly welcomed by a number of people because they thought, well, that'll take the political interference away from decision making. But unfortunately, what it's done inadvertently is it's also now created a scenario where many people, many members of the public are finding it difficult to feel that they're being represented because they can't lobby their local ward councillor or talk to their local public representative and say, oh, we think this is a very important issue. Can you make a decision, one way or the other? They are now faced with a panel of unelected officials who are now making those decisions effectively on behalf of the administration. So I think it's quite an important point. I think it's something which isn't looked into hard enough. And I think the implications thereof can have quite significant impacts going forward. Thanks.
Thank you very much. Does anybody want to comment on that? No. Yeah, noted. Okay. Maybe not quite what you guys work on. I think we should close the meeting now, just because it has been a very long meeting. So a really big thank you to all the members of Parliament for staying on and coming on so long. And part of the thing is not only to give you information from our perspective, but it's also to connect you with some of the resources out there that you can tap into when you have either issues in your constituency, or if you need also more help in terms of the portfolio work that you're doing, in terms of legislation work or policy or just background. So I also hope that that is, you know, of some help to you. A really big thank you to all the speakers. I know they put a lot of work into this, and for all their time. Thank you very, very much. I wish a good recess to the members of Parliament. I think you're going into recess quite soon. We will be back after the recess with some more briefings, but also, as promised and as discussed last week, with a trip to the Sustainability Institute. I hope you have a lovely day, and thank you again. Have a good one.